Hi, this is lecture 5 for the immigration training, 6-hour training course. During this lecture, we are going to look at a statement of the law and what exactly it is and how it's actually used in immigration court. We will also be looking at some techniques for site translation. We're going to define it. We did that already briefly in lecture number 1, but we're going to go much more in detail, see how this is generally use in immigration court, if used at all. Sometimes there are not too many side readings that you end up doing in immigration court, but we will look into the techniques in how to properly deliver those documents into the opposite language. We will be looking at some immigration terminology that you have in your manual. We're going to look at what's in your manual, what you need to do. We're also going to look at what you have to practice during this after completing this lecture 5 and before you begin lecture 6. What are the practices you need to do in the laboratory, in the online laboratory, and then we will be doing a simultaneous practice dealing with statement of the law, and we'll do that at a reasonable speed. Now let's talk a little bit about statement of the law and what it is. If you look at an immigration case, as we discussed in lecture 1, you have a master calendar hearing and an individual merits hearing. In the individual merits hearing, which is equivalent to a trial, really, the judge has to make a determination regarding an application that has been submitted by the respondent. That determination, generally, it's done in written form. It's not done verbally right after the case is completed. But there are some judges in different jurisdictions where they do that verbally. So you're going to have a mix here. In other words, as we discussed last lecture, when we talk about court orders, these court orders sometimes are sent to the party in written form, but sometimes are actually put on the record. Don't expect in every single case a court order or statement of the law. But in sufficient number of cases that those two are included in the decision, and as a result of it, you need to know how to interpret them. What are the challenges, and what is a statement of the law? Statement of the law basically is the judge putting on the record the basis under which the application was filed, or that the application was denied, or the application was granted, the basis under which voluntary departure was offered to the respondent, and they are all basically legal basis. So expect in statement of the law, which, by the way, it is always interpreted in the simultaneous technique. In statement of the law, expect a lot of legal terms, legal expressions, name of cases, sections, different codes. CFR, Code of Federal Regulation, for example, comes out occasionally. And sometimes these are abbreviated. So the first problem that we have as an interpreter in immigration court is how are we going to be able to interpret all those sections and codes and things like that as we hear them? Because as you probably already figured this out, it's very difficult to interpret in simultaneous numbers, sections, and words all mixed together. It's usually very complicated because the words do create a message, and it's easier for us to follow it. But when it comes to factual information, particularly numbers, section of a code, names of a code, that becomes a little bit complicated. Now, there are, of course, some sections that are very commonly used in immigration court, like 240A, which is to be eligible for cancellation of removal. Because one of the things that happens is that when the respondent shows up in immigration court, one of the things that the respondent is requesting is the cancellation of removal. Because what do you mean cancellation of removal? Well, if there are some allegations against him in the notice to appear against the respondent, and the respondent has some grounds to stay in this country, the first thing that needs to be done is canceling the cancellation of removal. That might be one of the requests, an application for a cancellation of removal. And that is under Section 240 A of the Immigration and Nationality Act. So you're going to see that as something common. You're going to hear that a lot. 240A is very commonly used. So those sections, yeah, you should really memorize them, and you should know when it deals with cancellation of removal, that is definitely the section that you need to keep in mind. But there are times that the sections are just way out there that you don't hear that often, and you just don't know what they are, and you have to interpret them. Well, the Chief Judge of Immigration has sent a memo almost a year ago, indicating that sections of the code may be omitted by the interpreter, or you may use things such as, for example, and under the corresponding law. So if you see, for example, under section 23667, subsection A, subsection B of the Act, you could say under the corresponding sections of the Act, instead of actually specifying what the sections are. But the expectation is that if the section is used, a very common one like 240A, that you should be able to know that. Sometimes there are some cases that are mentioned, and they are referring to some prior cases, and they talk about names and things like that. So if they say, for example, in the case of U.S. government versus Mary Kim, for example, and then it says, so it gives you information where that case was heard and all that stuff. You can simply interpret, instead of interpreting all that, if you want to, you can simply interpret that by saying in a case that established precedent, because that's what it refers to, a case that established precedent, okay? So you have two options when you hear a section, a number of sections, section blah, 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 of the Immigration and Nationality Act. Sometimes it's abbreviated as INA, okay? They even abbreviate it to make it more difficult. You can transfer this into the opposite language as, and there's under here, under the corresponding sections, because this is plural, of the Act. So these two are the same. They are the same for purposes of transferring the message. You are allowed to do that so that you don't concentrate too much on the sections, on the numbers, and the risk in concentrating on the sections. I'm sure you can deliver the sections if you pay close attention to the numbers. But the risk is that it's going to slow you down, and it's very possible that you're going to be missing information now, words, context, really, something that is important for the respondent to know. You may be omitting that simply because you concentrated too much on the section. And if you think about it, what's more important for the respondent? The definition of a section or the section number? And clearly the definition is way more important. So this is the justification for you to use something that allows you to stay on top of the original. In other words, to keep up with the speed. Now you got to remember that this statement of the law sometimes is delivered at 160 words per minute, which is very, very fast. And you will see when you go to your online interpreting laboratory that the practices will be, again, at 130, 145, and 160. And it's quite a challenge to be able to interpret at 160 this statement of the law. Now, what happens for you as an interpreter when you're interpreting a statement of the law and you're falling behind? Well, we apply the same rule that we initially discussed in lecture number 1. And that rule was that if you fall behind, you basically have no other alternative than to skip parts of the original. If you skip parts of the original, maybe the message is not clear to the respondent. So when you see that you're getting really behind, it's okay to tell the respondent, I'm sorry, but the judge is speaking too fast, so I missed this part. But then you continue with the rendition. So for example, let's say that the original is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And by the time you say 1, 2, 3, 4, the original is it's already number 7, so you don't remember 5 and 6. So you will say 1, 2, 3, 4. Sorry, but the judge is going too fast, and I didn't catch that. And then you'll say 7, 8, 9, and 10. So the part that you miss, which in this case 5 and 6, you basically tell the respondent why you are missing instead of leaving it completely blank. Because if you leave this completely blank, one of the problems with leaving this completely blank is that the message is completely distorted. And we have this parameter that I believe we already talked about this, that has to do with the interaction between the respondent and the interpreter. And our job, besides interpreting, is to always keep that interaction in the positive side. And interaction, as you may or may not recall, it is defined as the how much attention is the respondent paying to the interpreter instead of trying to understand what the English message is. And you want that respondent to pay attention to you, not to the judge, and trying to figure out what is that, or what is he saying. Because after all, that's your job there, is to communicate and to transfer. You're a conduit from one language into the other. But that conduit, it's not something that is going to flow in a way that you will know all the words, but it's a conduit of information, of a message. So when you don't know certain things, or you're falling behind, or the judge is speaking very, very fast, you need to tell the respondent why you are not delivering all that. Of course, technically, you will have to tell the judge to slow down. You will say, Your Honor, the interpreter cannot keep up with that speed. Can you slow down? But it is not advisable you do that in immigration court, because most likely you will be kicked out of the courtroom. So one thing is an ideal world, and a different thing is the real world. In an ideal world, you should have the ability, well, you do have the ability, but you should be given the opportunity to tell the judge that you can keep up with that speed. If you do that in an immigration case, they will kick you out, because they will say, well, I need somebody who can keep up with the speed. Obviously, you can't do this job. So you have to also evaluate what's ideal versus what's real. And in this case, the best option, instead of interrupting the judge when it's going that fast, is actually to share with the respondent why you are omitting certain parts. The ideal scenario, of course, is that you don't omit anything. So what I'm telling you, this procedure, I guess, or protocol, it has to be followed once you feel that you're missing certain parts of the original. And you want to fill in the blanks by actually saying to the respondent, telling the respondent why. But you have to continue interpreting, okay? It's really important, okay? Because your task is to deliver most, if at all possible, the whole message very accurately. But if you cannot, for whatever external reason, be it that it's too fast, be it that you cannot hear very well the judge, be it that the judge has an accent that you have some difficulty understanding, whatever the case is, in an ideal world, you will tell the judge to speak, slower and all that. But in a real world, you basically cannot do that, because they will get rid of you. They will just ask you to leave the courtroom, and they'll find somebody else. Some judges may not do that, but in general, they may even disqualify you for being unable to interpret at that speed. And we all know that this is a very challenging job, because the job itself, trying to interpret at 160 words per minute, statement of the law with court orders and with all these sections and things like that are associated with this type of proceedings, it's not an easy task. So as you gain more experience, then you will get much better. Now, it's really important that you do look at when you finish with that particular interpretation, you ask yourself, which are the things that I had difficulties with? If you had difficulties with speed, then you make an effort to interpret the speed, okay? If you have difficulties with certain words, and you probably wrote them down, and when whatever you remember, you write them down, look them up, and be ready for next time. So expect the statement of the law to be a rather complicated thing. At what stage is this used in a case, in an individual merits hearing? Well, again, as I told you, this may be sent to the parties in writing, but if it is set on the record, it's going to be at the very end. Once all the witnesses testified and all the evidence has been submitted, think of this as a final decision made by the judge. And that final decision will have the orders, what's going to happen to this respondent, what's going to happen with the application that was filed by the respondent, and it will also have the statement of the law that is the foundation of those particular orders, and it are the basis for which the court heard that particular request for that application for whatever type of relief. Remember, relief is like a benefit that you receive from immigration. So what we're going to do is I want you to listen to one of this statement of the law. I don't really want you to go and look at your manual now. I'm going to be playing this statement of the law twice. The first time you don't look at the manual. This will be, of course, under lecture number 5 in your manual, where it says, let me just look at the heading for that. It says, lecture number 5, it says immigration terminology, and then it says immigration proceedings, and it says statement of the law, and then it says key terminology for statement of the law. I'm going to be playing the statement of the law, but I don't want you to even look at the manual, please. Don't do that at this point. Just try to interpret as much as you can. Again, record yourself. And then when this lecture is over, listen to that recording plus the recording of the second time that I'm going to play this particular practice. And the second time I'm going to allow you to go and look at the key terminology for the statement of the law, which you have translated into your language. It's in your manual. It is already translated into your language. But right now, do not look at the book at all. Prepare your recording device and interpret this. This is at 130 words per minute, so it's not the fastest. It's actually the slowest that you will ever find. And interpret this into the opposite language, into the foreign language, into the language other than English, okay? So here is statement of the law. Interpret using the simultaneous technique.
Statement of the law. To be eligible for cancellation of removal under Section 240AA of the Immigration and Nationality Act, an alien must demonstrate that he has been lawfully admitted for permanent residence for not less than 5 years. He has resided in the United States continuously for 7 years after having been admitted in any status, and has not been convicted of an aggravated felony. As was explained in matter of CVT Supra, factors pertinent to the exercise of discretion under Section 212C are equally relevant to the exercise of discretion under Section 240A of the Act. For example, favorable considerations include such factors as family ties within the United States, residence of long duration in this country, particularly when the inception of residence occurred at a young age, evidence of hardship to the respondent and his family if deportation occurs, service in this country's armed forces, a history of employment, the existence of property or business ties, evidence of value and service to the community, proof of genuine rehabilitation if a criminal record exists, and other evidence attesting to a respondent's good character. Among the factors deemed adverse to an alien are the nature and underlying circumstances of the grounds of exclusion or deportation, now removal, that are at issue, the presence of additional significant violations of this country's immigration laws, the existence of a criminal record, and if so, its nature, recency, and seriousness, and the presence of other evidence indicative of a respondent's bad character or undesirability as a permanent resident of this country. In some cases, the minimum equities required to establish eligibility for relief under Section 240 AA, for instance, residence of at least 7 years and status as a lawful permanent resident for not less than 5 years, may be sufficient in and of themselves to warrant favorable discretionary action. However, as the negative factors grow more serious, it becomes incumbent upon the alien to introduce additional offsetting favorable evidence. With respect to the issue of rehabilitation, a respondent who has a criminal record will ordinarily be required to present evidence of rehabilitation before relief is granted and as a matter of discretion. Statement of
Okay, so as you notice, this practice is not an easy practice, even though the speed was 130 words per minute. When we finish with this lecture number 5, and I tell you what practice to do in the online laboratory, you're going to have the opportunity of practicing the same practice, but at 130, 145, and 160. And I believe there is a second statement of the law at those 3 speeds as well. And as you increase speed, it becomes way more complicated. Now, one word of caution regarding this, because sometimes it happens that you want to summarize instead of interpreting everything. That's called paraphrasing. And paraphrasing is always dangerous because you are not in a position to summarize things because you don't understand the law. So when you summarize, you clearly explain what you hear instead of interpret what you hear. And that explanation assumes that or takes into consideration the fact that you are understanding the message and then transferring the message using different words. And that's not advisable at any time. What you try to do is, of course, is interpret all the words, everything that you hear, making sure that the corresponding message is transferred. Another important thing about any practice that deals with simultaneous, particularly simultaneous at this speed, is that sometimes, as we mentioned before, you may get stuck with one term. That's the worst thing you can do. If you don't know a term, just keep going. And if it's just one term, skip it and keep going. Now, if it is a series of terms, then you got to tell the respondent why you're skipping so much. And you will say, for example, I'm sorry, but I missed a few of the terms, and then you continue interpreting. But if it's just one term, skip it, because most likely the message will not be altered that much, depending on which term you're going to be skipping, obviously. And the third thing that I want to point out here is that some people say, well, this is so technical. How could the respondent understand all this technical language? Well, it is not our job as interpreters to sort of digest this and then explain that to the individual, to the respondent. Our job is to interpret the original message as close as possible to the original message, I should say, making sure that the register of the message is kept at the same register than the original is provided to you. In other words, if the judge is using complicated words in the original, then in your language, in the target language, you will use complicated words. Now, whether the person understands or does not understand, it's not something that we are going to be too obsessed about at this point, because our job is not to explain. Most likely the respondent at this stage will have an attorney, and the attorney will be able to explain all these technicalities. But you are an interpreter. You are not an attorney. And as a result of that, you are not in a position to justify any type of explanation because you don't have the legal training. and you don't know immigration law to the extent that is necessary to be able to explain something as complex as the statement of the law, which basically explains the law. So please deliver this not paraphrasing or summarizing, not like getting a message and then saying your own message. Just deliver. I understand that sometimes in some languages you do have to to wait a few words until you can structure the transfer correctly. That's fine, but it's different than, for example, the original is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and then in number 10, you basically, instead of saying 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, you say count it from 1 to 10. That's not good. It has to be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, because otherwise you're basically explaining, and that's not what we are here for. And the level, if it's difficult, it's difficult. Who decides whether the level is difficult? Well, it's the original, not you. So if somebody who is, let's say, for example, somebody who appears in immigration court and that person speaks English, that person is going to hear the same statement of law and is going to be a very high register material, meaning that it's very legal and very confusing. So that person and somebody who speaks any other language than English, there shouldn't be any difference. But if you, as the interpreter, instead of interpreting the words, you explain and lower the register so that this person understands, then you're really playing the role. Two things happen. You're not being fair, because if the one that speaks English doesn't have that privilege, why would the one that speaks any other language but English should have the same privilege? So it has to be fair. And the second thing is that you are putting yourself in a position of an attorney, which you are not. And even if you are actually now acting in the capacity of an interpreter. So you will have to interpret the words and the message, but not summarizing, not explaining, not lowering the register. Now I'm going to invite you to do the same practice, but now I'm going to ask you please to go to your class book, class manual, and again under, let me see here, it is under lecture number 5. When you look at the table of contents, that's what I'm looking right now. On page 3, it says lecture number 5, immigration terminology. We'll talk about that shortly. Then it says immigration proceedings, statement of the law, and then it says key terminology for statement of the law. I want you to go to that page that says key terminology for statement of the law. Once you are on that page, you're going to see the translation of selected expressions from the actual statement of the law, from the script that corresponding to the practice that you just finished. And that is already translated into the target language, so you can refer to it. And now you're going to be interpreting and the same practice, but you're going to be referring to the translations of those selected terms. And it should be easier. And of course, you need to be also recording your interpretation so that at the end of lecture 5, you can compare both, okay? So get ready to do that. Get your recording device ready. Be on the key terminology for the statement of the law on the lecture 5 page there, ready to don't look at the script, the previous page that says statement of the law, immigration proceedings, statement of the law. Just actually look at the transfers where you see key terminology for statement of the law. The first word that you're going to see there is to be eligible for cancellation of removal, and the translation is provided right below. And then an alien must demonstrate blah 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 blah, and it continues on the back of the page, Janet. So make sure that you turn the page when it gets to that point. So once again, you're going to do the same statement of the law in simultaneous and record yourself. Okay. All right. So here it goes. Statement of the law again, simultaneous.
The law. To be eligible for cancellation of removal under Section 240AA of the Immigration and Nationality Act, an alien must demonstrate that he has been lawfully admitted for permanent residence for not less than 5 years. He has resided in the United States continuously for 7 years after having been admitted in any status and has not been convicted of an aggravated felony. As was explained in matter of CVT supra, factors pertinent to the exercise of discretion under Section 212C are equally relevant to the exercise of discretion under Section 240A of the Act. For example, favorable considerations include such factors as family ties within the United States, residence of long duration in this country, particularly when the inception of residence occurred at a young age, evidence of hardship to the respondent and his family if deportation occurs, service in this country's armed forces, a history of employment, the existence of property or business ties, evidence of value and service to the community, proof of genuine rehabilitation if a criminal record exists, and other evidence attesting to a respondent's good character. Among the factors deemed adverse to an alien are the nature and underlying circumstances of the grounds of exclusion or deportation, now removal, that are at issue, the presence of additional significant violations of this country's immigration laws, the existence of a criminal record, and if so, its nature, recency, and seriousness, and the presence of other evidence indicative of a respondent's bad character or undesirability as a permanent resident of this country. In some cases, the minimum equities required to establish eligibility for relief under Section 240 AA, for instance, residence of at least 7 years and status as a lawful permanent resident for not less than 5 years, may be sufficient in and of themselves to warrant favorable discretionary action. However, as the negative factors grow more serious, it becomes incumbent upon the alien to introduce additional offsetting favorable evidence. With respect to the issue of rehabilitation, a respondent who has a criminal record will ordinarily be required to present evidence of rehabilitation before relief is granted and as a matter of discretion. Statement of the law.
Okay, so now this should have been much easier, hopefully. And one of the things that you will do after you finish lecture number 5 is to basically listen to both renditions and determine which one was the one that makes more sense. You always follow this rule when you listen to your rendition. Pretend to be the respondent who does not speak English. And ask yourself, do I understand what this person is telling me, what this interpreter is telling me? So that's something that you should always, that's the best way to evaluate your interpretation. What you want to do is make sure that the person understands what you're saying. And the only way you can do that is if you listen to the rendition. There's no other way out. Okay. Now, let's see. We also have in this lecture number 5 some immigration terminology that you need to review. It's all translated for you. So let me tell you exactly where that is. Lecture 5, it says immigration terminology. So if you go to your table of contents, page 3, under lecture 5, immigration terminology, you look at that page, and you go to that page, please, and the first word that you're going to see is rank order number. And it ends with, you have plenty of terms. In fact, this is a lot of it. It ends a few pages after that with voluntary service program. Now, the definition of those terms are there in English, and the corresponding translation into your target language is also included. You need to study those. Again, you create your flashcards, You review them, you study them, and then only after that, after you study those, then you can move on to the statement of the law, which is the page that continues afterwards. And in the same lecture number 5, you will see the script. Some parts of the script are underlined. So you look at the underlined ones, the translation of those selected terms that you just referred to during this practice, and you study those as well. Now, in this ones, it's very important that you study not just the individual words, but rather the whole expression. For example, to be eligible for cancellation of removal, that's what you write in your flashcard. Now, the second one is rather long, it's 4 lines long, so I'm not sure how you're going to write that on your flashcard, but yet it is a very good idea to write the whole thing. And why is it so? When we interpret using the simultaneous technique, what happens is that let's say you have, for example, an expression such as an alien must demonstrate that he has been lawfully admitted for permanent residence for not less than 5 years, blah, blah, blah. That's second option there, all right? Or second key selected term. It's really not a term, more like a sentence. When we interpret, we are searching in our brains when we hear the word, how do I say alien? How do I say demonstrate? How do I say lawfully? How do I say admitted? That's going to really slow us down. Why? Because we are searching, every time we go and search in our brains the proper transfer for a given term into the target language, there is a delay. It's a fraction of a second, but it's still a delay. So when that occurs, and you will be probably going into your own internal dictionary many times for that particular long sentence. What happens is that by the time it gets to the very end, which has not been convicted of an aggravated felony, and it continues, the original continues, as you can see in the script, as was explained in matter of CVT, blah, 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 supra, factors pertinent to the exercise, blah, blah. What happens is that you are so far behind that you have no other alternative than to leave things out. However, if you memorize this as a block, and you know that the statement of the law has to do with to be eligible for cancellation of removal, you automatically know that this block is going to come up. And as soon as you hear the judge saying an alien must demonstrate, you got to say this in your target language as fast as you can. And sometimes you say it so fast that you are ahead of the judge, so you slow down. But it's always preferable for you to have control of the speed than the judge have control of the speed. So that's the best, the only way you can really interpret at 160. And this should apply to any type of simultaneous. You practice it many times, you're familiar with the statement of law, you're familiar with the court orders, you're familiar with Life Act, which it's actually in your online laboratory, and you will see it in the practices that you're supposed to complete after finishing this lecture. You're familiar with all that, and you should really look at the whole sentence. So once you hear the beginning of it, then you know the interpretation of the whole thing. So you're really going into your database there in your brain once to pull out one whole segment, not individual words. When you pull out individual words from your database, when you retrieve them individually, they will take way longer than if you retrieve a whole segment. But that can only be done if you have done this practice many, many times. So many times that you almost memorize them in English. And it's okay if you memorize the original in English. It's okay because it's going to be the same regardless. No difference. It's going to be maybe, sometimes the variation deals with the name of the person, but in general, this court orders and the orders will be different. But once you know what type of order it is, then you will have a very good idea of what's coming. So the way to memorize this thing is by blocks, not by individual words. Really important. It's going to make a huge difference in your interpreting skills, your simultaneous interpreting skills. And this applies to anything that is very convoluted, very legal, very abstract, and very repetitive. Once you memorize the whole expression, it's always easier to deliver the whole expression than to search for or retrieve the individual elements of that expression in your dictionary, internal dictionary, I call it. So that's how you should create the flashcards here, okay? And some people say, well, but how many times, if I practice it 15 times, that's not a good idea. Of course it is a good idea. You practice 100 times, it's a great idea, because the more you practice something that is repetitive, that you know all the judges will use regardless, and that would always be the same, the more you practice, the more it's stored in your database. And first of all, your ear is much more used to the vocabulary, the sentence, the structure, basically the format, and that's good. And second, your interpretations are flowing by segments, not by individual words. And that's when you can keep up at very, very fast speed. Otherwise, it's extremely difficult. So you should be doing that, okay? So one thing that I recommend students at this point is that when you look at, for example, the script of the practice, in this case is the script of the statement of the law, the one that begins to be eligible for cancellation of removal, just get different sentences from here and try to repeat them in the target language as fast as you can, out loud, of course. Of course, you can use the ones that we selected for you, but there are some other things here. For example, factors pertinent to the exercise of discretion under Section 212C are equally relevant to the exercise of the discretion under Section 240AA of the Act. That might be considered to be a structure. So find the corresponding translation of it and repeat it out loud, not in your head, out loud as fast as you can. Memorize it and repeat that for the whole script, okay? So that's what you will do in here. And then once you complete with these two things, the immigration terminology and the statement of law, then you will be able to go to the lab, okay? Now, what are you going to do in the lab? Let me explain it now, and then we'll go into site translation techniques, okay, in preparation for lecture number 6, actually. Okay, if you go to your online laboratory manual, to the contents or table of contents on page 3, you will probably have to turn to page 4, because page 4 it says on top, practices to be completed after finishing lecture 5 and before beginning lecture 6. All right. So when you look at that, it says that you have to do practice 27, 28, 29, which is the same practice but at 3 different speeds. And then 30, 31, 32, which is the same practice but at 3 different speeds. How are you supposed to do these practices? The same way you did it here in class. In other words, you will first play it at 130, try to interpret. It's going to be the same. The first 27, 28, and 29 happens to be very similar. Not exactly the same, but very similar to the script that, in fact, it's almost identical, really, to the script that you did here in class. I mean, we can't really change statement of the law that much because that's pretty much written. It's going to be like that, no matter what. So try to do at 130. Record yourself, see whether you're delivering most of it. If that's the case, then you move on to 145 and then to 160. If you realize that at 130 I can deliver, at 145 I cannot, it's very possible that you are concentrating too much on the individual words instead of the whole segments. So it might be a good idea to go to your online laboratory, the scripts for practices 27, 28, and 29. I'm talking about the laboratory manual. Just go to the scripts, okay, on pages for practices 27, 28, 29. It's just with the same script. And see where there are some segments that you can memorize as a whole segment. And just memorize it as a whole segment. And then try 145, and you're going to find out that it is way easier now. And of course, when I say memorize it as a whole segment, you also have to be able to say it out loud very, very fast, okay? Very fast. So when you're memorizing it, you not only memorize the meaning of it, but you're repeating it very, very fast, okay? And you do the same thing for practices 30, 31, and 32. And that will definitely complete the practices for that you have to complete after lecture 5 and before lecture 6, all right? So that's pretty much it in terms of the assignment of what you need to do before you attend lecture 6. Now, lecture 6, we're going to be looking at a new component called sight translation. So we would like to look at some techniques here so that when you attend lecture 6, you're already familiar with the format in which you should be handling sight readings. In lecture 6, we'll do a little bit more of sight translation techniques. Now, sight translation is that particular technique that you get where you are given a document, say it's written in English, and you ask to transfer that into the target language, into the foreign language. Or you may be given a document in the foreign language, and then you're asked to transfer that, verbally interpret that into English, okay? Now, this is very different than consecutive and simultaneous that you have been doing. Simultaneous, you hear and interpret. And speed is really a factor, not in sight, because you pretty much can have your own pace, although the standard is that for a 3/4 of a page document, it should not take you more than 3.5 minutes to deliver it. But you're much more in control. Whereas in simultaneous, who is in control? Really, the speaker is in control, the judge, in terms of speed. Now, you can diminish that control by studying segments if, as we just discussed, if the simultaneous is a repetitive one, which generally it is. But still, the control is handled by the speaker. In sight translation, you are in control. It's a limited control because you still have to deliver within 3.5 minutes, 3/4 of a page. But it's not, you're very much in control. I will say 80% in control at least. So what's the purpose then? And of course, in consecutive, it's very different. You hear the whole message and then you interpret. Here you really, the sight is a little bit closer to consecutive because you read the whole segments, all the segments, and then you deliver. But you can, the rule is that if there is a period, you can pause, but the pause should not be too long. In other words, when there is a period and you pause, if I count to 3 and you haven't started yet, then you are already behind. Your style is not the style that you should have. And the other important thing about sight translation is that you only pause when there is a period. You don't want to pause in the middle of a sentence. So if you're rendering, let's say, from the foreign language into English, and your rendition is like this, the immigration judge determined that that your application for cancellation of removal will not be granted on the basis that, now that's not good style. A much better style is, the immigration judge determined that your application for cancellation of removal, and please notice that I slowed down in the delivery, so I have a little bit more time trying to restructure this in my head if I have to. I can't slow down that much that I don't finish within 3.5 minutes. But yet I have to slow down if I feel that the structure is very difficult. So in other words, so look at the screen here, for example. If this is your sight translation, you may have one part of it that it is very, let's say, legal. Then you may have another part that it is more general vocabulary, regular vocabulary. And then you may have another one which is general vocabulary and another sentence that is very legal. It is okay to have a pace for this too that is different than the pace for the general. In other words, here you may be slow in the delivery. Here you will be a bit faster. And it is okay. But within that block, the pace at which you deliver should be constant. So if it's slow throughout. You don't want to speed up and then slow down or slow even more. So the key is that within that sentence, that block, okay, which should be 2-3 lines long or whatever, you are constant. Your pace is constant. But if the pace is constant, and let's take the example of driving. If while going through this neighborhood, you are driving at 15 miles per hour, that doesn't mean that you have to drive through 15 miles per hour in this neighborhood that is general. Maybe you can go at 25 miles per hour and it's okay. And maybe here also 25 miles per hour. And maybe here in legal, you're going to bring it down maybe to 10 miles per hour because it's very convoluted. The speed at which you render this, the pace, is directly proportional to how convoluted the structure is. And when I say convoluted, it's not only necessarily vocabulary. It could be the way the structure is created, because when you transfer from English into many different languages, sometimes in some languages it's true that the structures are similar to English, but in other languages they're completely different. Sometimes the verb goes towards the end, and it's way more complicated. So yes, you do need to slow down to structure it accordingly. Now, it's possible that even in the general, you have to slow down even at the same speed as in the legal, because the structures are a problem in your language. But if the structures, the grammatical structures, are not a problem in your language compared to English, if they are similar to English, or at least not very, but at least somehow similar, then the space at which you're going to be delivering each structure will be heavily dependent on the vocabulary, and will be heavily dependent on the vocabulary, on your knowledge of the vocabulary. So it's okay to slow down in the certain portions of it, and you don't necessarily have to have the same pace throughout. But the key is that if you have paragraph 1, 2, 3, and 4, for paragraph 1, you keep a very constant uniform flow. That uniform flow, that speed at which you render, the pace at which you render paragraph 1, does not have to be the same as the pace that you deliver paragraph 2. But paragraph 2, if it's faster, is fine. The pace is faster, but you must keep a uniform delivery in that paragraph. Okay? So that's called style of delivery. So you don't want to pause when you don't have to pause. And then you say, well, how could I deliver this if I cannot pause when I don't know a term or think a little bit about a term? Well, generally when you are given a sight translation, let's say in your final examination for this training program, you will be given a certain period of time to read it. And, it could be a minute and a half, it could be 2 minutes. It depends on the length of the original. And during those 2 minutes, what do? Well, you need to look at each paragraph and look for 2 basic things, which is what we just discussed: the structure and the vocabulary. The structure is always harder than the vocabulary. If you don't know a word, it's okay for you to leave the word in the original language. It's okay, or even to skip it. But so you always have a way out. But when it comes to structure, you need to know where to put things, the right word order. Otherwise, the meaning of that particular structure will be completely distorted. So the transfer is not accurate. So during those 2 minutes, you concentrate on the structure and say, oh, okay, no, this transfers. I know this is not a big deal. Okay, this one is I have a problem with this word. And then another problem here, another problem there. Okay, so then you go back, if you still have time, and you try to see whether you know the meaning of the word. Sometimes you will understand the meaning of the word in the original document. You know what it means. If I say, for example, cancellation of removal, you do understand what it means, but you may not remember how to say it in the target language. If you are in a situation like this, it is okay to explain it as close as you can to the original. Now, if it's a legal term, it's a little more, but if it says, for example, cancellation of removal, and you don't know the exact transfer into the target language, you may say, for example, cancellation of the order that will deport you. I mean, that's close enough. Okay? Now, so that's a possibility, and it should be used, because in a final examination, you're going to get, some at least partial credit for that. In real life, it's preferable that you explain something you understand clearly what it means in the original language into the target language when you don't know the exact transfer. It's preferable that you do that. But then there is the other possibility where you read something in the original language and you don't even understand what you're reading. You don't understand that word. You don't know what cancellation of removal is. In that case, don't waste any time. Just keep reading during those 2 minutes that you're given to, or minute and a half, that you're given to read that document. Because if you don't understand, if you don't comprehend the original language, the word in the original language, there's nothing you can do. You pretty much will not know that term. So don't try to make things up simply because there is a gap here, you're going to say something. No. If you don't know it, you skip it, or you leave it in the same language. And so there are two options. When the term is a term that you understand in the original document, but you don't know what is the exact transfer into the target language, in that case, if you know how to explain it, you will explain it. But if the term that you read in the original document is a term that you have no clue what it means in the original language, in the original document, in other words, you don't understand, there's no comprehension of the source language of the original. If you don't know, then don't worry about it. Just keep reading. Use that minute and a half of 2 minutes to look for other areas. Don't spend much time on it because nothing will help you, really. If you don't know it, you will skip it when it comes to that particular term. And definitely do not add things that are not in the original. The worst thing you can do in interpreting is to embellish, to add things to the original. That's heavily penalized in most interpreting exams. And rightly so, because you're basically putting words into the words of the original or into the words of the respondent, the witness, or whatever, and that's not what we're supposed to do. So when it comes to side translation, the key is uniform pace per segments. When you're given time to read, and that doesn't mean that it has to be uniform throughout. You can have different segments at different speeds, or pace, I should say. The other important thing about those particular segments, or the side translation, is that the style is important. You cannot pause when there is no period, only pause when there is a period, and you shouldn't pause for more than 3 seconds. Now, when you pause, because the sentence ends, what you do is you start reading a little bit ahead of you. You start reading the next segment. What sometimes students do, and that's not advisable, is that they read the whole sentence, and everybody's waiting. Maybe it takes 10 seconds, and then they start the delivery. And then they pause when the sentence ends, and then they read the next sentence, and then they deliver. So it sounds da-da-da-da-da-da-da-da-da, and then long, prolonged pause while the interpreter is reading the next segment, and then da-da-da-da-da, and that's not allowed. This has to have a uniform flow, okay? Very, very important. So when you pause, you can read the beginning of the next sentence, okay? And you can read, the first 2, 3, 4, 5 words, but then you got to start right away because you don't want to leave very prolonged pauses between each segment in side reading. It's not allowed, okay? And the other thing, what we're going to see in lecture number 6 is something that has to do with restructuring and, well, not necessarily restructuring, but what to do when the structures are very convoluted, okay? So we'll look into that. And here we're really looking more into the style of the delivery and into the vocabulary. An important observation regarding style. It has to be, you have to read it with a tone of voice that people can hear it. If you're reading this to everybody who in the courtroom, you have to read it out loud. If you're reading just to the respondent, then you don't have to read it that out. The tone of voice has to be the right one. Okay, that's very, very important as well. No omissions, no additions or embellishment. Uniform flow. Okay, proper restructuring. Vocabulary, proper transfers. If you don't understand, if you don't comprehend the original word in the original document, then don't pay much attention to it. Just skip it or keep going because there's nothing you can do. But if you do understand it and you don't remember the exact transfer into the target language, then explain it. That will be fine. That will work fine as well. And do this within a period of time, which they will give you in the final examination as well as in court. You can't take forever to do this in court. All right, so you know what you have to do, what you have to study, and you also know what practices you must complete before you attend lecture number 6, which incidentally will be our last lecture. Just want to make sure that right now that you also have already scheduled your the date and time for your final examination. I believe the button is in the video lectures, in that part, button below lecture number 3, I believe, between lecture 3 and 4. There is a button to schedule your final examination. Follow the instructions. You should have done that already, but if you haven't, please do so, because you still have you only have one more lecture to go, and you should schedule it for the next maybe 4 or 5 days, 3 4 days, or whatever it's available. Okay? All right, so this ends lecture number 5. Thank you.